Since we have a live stream audience of some people signed up, let's go ahead and try to keep as close to on time as possible. And I'd like to welcome all of you to the first of two alumni panels that are thinking back on 10 years. All right, thank you. And just so you know, I mean, we have programs. We have a number of 4 distinguished alumni here to help us look back 10 years. This is, go back to the time in 2007 where we were. And the conversation I've had with several people is, we all know there's been a lot of changes, but sort of it gives us a chance to think back and be struck by just how much things have really changed in different ways. And so we have with us, just going down the row, Will Ferrullo of Informa, who is going to talk about his experience in the content side, about how that has been transformed by the industry, about the changes that we've seen in the last decade. We have Barbara McClung, who's General Counsel of Caribou Life Sciences, a biotech company specializing in CRISPR technologies, who've seen all of the things happen pre and post Myriad in the world we've lived in the patent space. In addition to that, we have Thomas Penn, who works for MVP Capital Partners, a venture capital firm that is investing and having probably to take a very different view of all these things than the practicing side. And Lisa Soto from Hunt & Williams, who specializes in something that probably no one really thought of as a practice when we all started coming out of law school, but is now one of the fastest growing practices, which is privacy law. And so the intent is to keep this very informal. We'll give an opportunity for you to ask questions of the panel towards the end. But I thought I'd just start asking different people, just to look back 2007, what did the landscape look like and how have things changed? Why don't we just start with you, Will, and start working. I figure I'll then hop over to Lisa and then come back to you, Thomas, because I think the perspective you bring encompasses all 3 of these. So, Will, why don't you tell us? It's 2007.
Right. We've traveled back in time. Sure. So my company now, Informa, just to give you a little context on what we are, it's an information services company, professional information services, and that inevitably gets me somewhat quizzical looks because it sounds like something you know what it is, but you're not exactly sure what it is. But it's basically a mix of business intelligence, which is basically news, analysis, and data products for basically decision makers at different businesses in industries that we serve, trade shows, conferences, and we have a sort of separate division that's a little unrelated that is academic publishing. So that's what we do now. And I actually came to the company from a company that they acquired about 1.5 years ago called Penton, where I was for about 6 years. And that's really where the story I think of the last 10 years happened. So Penton, similar business, not the academic publishing part, but the other parts in terms of business intelligence and trade shows and that. So basically, Penton 10 years ago. If you traveled back 10 years and said, "Tell me about your company, Penton, this information services company that I've heard of," you'd get befuddled looks, not just because you had traveled back in time 10 years, but you were truly speaking this future language. Information services was not a term that we were using at the time, right? We were a magazine publisher 10 years ago. That's how we were known as business-to-business publishing, so very niche professional audiences, right? I like to joke about, I mean, we have agriculture, we have, food, we have all these different specialized areas. I always like to joke that if you whether you're a small time farmer or a big industrial farmer and you have pork products, we've got you covered with National Hog Farmer magazine. Don't worry about it. We got you. But news for these different industries is basically what it was. 10 years ago, predecessors to the company had been public companies and had been media companies in the 90s, which you would consider sort of traditional, although business-to-business media. Starting late 90s, early 2000s, of course, print revenue starts tanking, the industry starts changing, a lot of people are going out of business. We were taken private by 2 private equity owners who basically made it their job to turn the company around, as private equity owners will do, and try to sell the company off. When I actually joined in 2010, we had just gone through a bankruptcy proceeding, prepackaged bankruptcy, and so I came in as part of this wave of people who was trying to really, at our new ish owner's behest, really move the company from a traditional print publisher to a modern day digital information services company, which still was not a term in 2010, but became one soon after. So when I joined in 2010, I did look back for this a little bit. So at that point, 70% of our revenue was print revenue. So basically, some of that was subscription fees, but not that much. Mostly print advertising, right? Like you're reading through a magazine, you get a whole page, you get a half page, you get whatever. The rest was sort of split up, I would say 15, 20% for events businesses and a very small amount for digital businesses, which really at that point meant slapping your content on a website, right? And not really having a very sophisticated plan about how to monetize that. Fast forward to 2015, and we had really transformed the company. At that point, we reported our print revenues were down from that 70% to about 11% of the revenue for the company. Events had grown to 54%, so pretty significant. And digital had gone from barely anything to about 35% of the company. So I think that digital space is that's what I was working on primarily and was the most interesting to me. And that is where we really grew out. Instead of just slapping your content on a website and hoping that people pay you to put some ads up on there, we really developed a whole bunch of different products around that. We realized the value we really had for our readers was deep expertise and knowledge of these very niche industries. So we built up a lot of data products. That became sort of a big push for us, and a lot of what I worked on was sort of putting together these SaaS platforms that were a mix of industry data, sometimes some personal data for lead information for people, but basically building out that technology, and as we went along, making it more sophisticated with predictive analytics and those kinds of things to help decision makers from our readers make decisions about where is our industry going, what products are going to be the ones that we should be focusing on, what should we be leaving behind, those kinds of things. Some consulting grew up around that and those kinds of businesses. So data subscription became a very healthy part of our portfolio, where it really barely existed when I started in 2010. And marketing services was sort of this other area, which is basically a way of, instead of just saying when we started in 2010, you really were talking about banner ads on a website, right? Pretty simple kind of advertising stuff, not that different from print advertising. But we basically could offer to our customers, hey, look, we have this expertise in our areas, and we have this readership that's very engaged with our content, and we can help you read them more specifically. We can help tailor more specific content towards them, and this is where you get things like sponsored content, which you see on more and more websites these days, and has some controversy around it, and has some and that. Right? But there was a push in that area, but also just more generically, sort of. Reaching out, newsletters and email blasts to customers where we're kind of pushing out content that's more relevant, very, very segmented, learning the behavior of the readers who engage with our content, and then being able to offer the advertisers, okay, you're not just slapping your ad on there, but you're reaching out to these folks and offering them exactly what they want to see at this time of day, exactly when they want to. Stuff we're all familiar with these days, but again, 10 years ago, not so much what we did. So the point is, about a year and a half ago, that transition really became complete. We were bought by Informa, which is my current company, and that was why it was, for our private equity owners, considered a success story, because they made their exit, and they did pretty well with it. But it's a completely different company than I think 10 years ago, if you said, what is Penton? National Hog Farmer magazine, here you go. It's now we're sort of a data and networking company, consulting. So that's my long-winded answer to
well,
it looks.
Congratulations to your country for making a transition that many attempted to make and few did so successfully. So.
Yeah, B2B. I mean, we're lucky to be in a space where it's a specific area. Business to business is a little easier. You have professionals. They have budgets for this stuff. They are often long-time customers. We have some advantages built in that I think help, but it's still a lot didn't make it in the area. So, yeah.
Well, Barbara, from your perspective, if I was 2007, I said the word CRISPR, people would think it's something that came out of my oven.
Yeah, and so if I look back at 2007, that was the year that CRISPR actually was identified as a bacterial immunity system. And so people always ask, what is CRISPR? CRISPR stands for clustered, regularly interspaced, short palindromic repeats. Okay, so what is that? And what was discovered in 2007 was that just like we have immune systems, bacteria have immune systems. So if you or I go in and we get vaccinated, say against polio, we're actually given a bit of the polio virus, either in a killed form or in an attenuated non-virulent strain. And so then when we see polio, our immune system has already been revved up and is ready to protect us. Well, it turns out bacteria also have viruses that infect them. They're called bacteriophages, and through evolution, the bacteria have developed their own immune systems. And so what they do, what a phage does when it attacks a bacteria, it gloms onto the outside and it shoots its DNA into the bacteria, gets incorporated into the bacterial genome, and then it turns the bacteria into a little factory for making more phages. So what the bacteria have done over time, what they've evolved, is an immune system where when they're infected by a phage, they clip off a little bit of the phage's DNA and they incorporate it into their genome. And they make what are called RNA guides against it. So the next time they see that type of phage, those RNA guides can glom onto it and bring in a protein, a Cas protein for CRISPR-associated protein, that functions to chew up the phage DNA, and therefore the bacteria survives the attack and goes on to produce more bacteria instead of more phages. So that was identified in 2007 by people working at Danisco who were making yogurt, because they noticed that some cultures were healthy cultures and other cultures died off. And so they were able to genetically engineer cultures. So by adding these extra bits of DNA, they could actually give them immunity memory and come up with stronger cultures. So then fast forward to 2012, when a paper came out in June of 2012 by researchers at the University of California, University of Vienna, and University of Umeå in Sweden, where they had taken the bacterial system, called out what the important components were, and figured out a way to use it to do gene editing in cells. Cells could be plants, they could be animals, they could be humans. But using those RNA guides, they could go to a gene of interest, and then using this Cas protein, in particular a protein called Cas9, they could use it as a pair of molecular scissors and actually cut out a deleterious gene, insert DNA. And so that came out 2012, and the field just exploded. CRISPR-Cas9 gene editing has been called the invention of the century in biotech. There had been gene editing methods before, such as zinc fingers and talons, but they were expensive, they were time-consuming, and they weren't very accurate. And the last thing you want is a protein in there chewing up your DNA in places you don't want it clipped. And so at this point, there are now 3 companies formed in the human therapeutics area around CRISPR-Cas9. All 3 of them went public in 2016. So it's been an explosive field. If I take a look back where we were 10 years ago in patent law, we were still in a first to invent world in the US. And what that meant is if 2 people filed on the same invention, the patent office would have what's called an interference. They would look at lab notebooks, they would take corroborating evidence, and they would determine who the first to invent was. In 2013, we switched over to first to file, like the rest of the world. So whoever gets to the patent office first gets the patent application, or gets the patent. But for better or worse, the patents were filed in 2012 under the old system. So whereas most people thought interferences were dead, most interference practitioners had retired, all at once CRISPR comes in with 2 competing groups. There's a group that's the University of California, Vienna, and the UMEA scientists. Full disclosure, Caribou, where I'm at, is the exclusive licensee of University of California in Vienna. There was a group at Harvard, Broad, MIT, who filed 7 months after the University of California filing. Had we been in a first-to-file world then, there'd be a lot of lawyers who aren't making a lot of money as they are today. But we have turned out to be one of the last great interferences. So here we are, 5 years after we switched over to a first-to-file system, back fighting one of the biggest, and the stakes are probably the highest, interference in the CRISPR-Cas9 area. So that's, when I look back, science and patent-wise, that's what I see.
Lisa.
That was really impressive. I do privacy and cybersecurity work. So I'm going to confine my remarks to 3 areas: privacy, government surveillance, and cybersecurity. So starting with privacy, I mean, I will say back in 2007 when I went to cocktail parties, and Milo Cividanis was probably one of fewer than half a dozen practitioners at the time in this area. It was really not sexy at all. It was incredibly esoteric. But, you know, at cocktail parties, people would say, wait, you do IP work? Like, no, no. Start all over again. Now, front page of the newspaper every day. So there's no need to explain what we do anymore. Privacy, back in 2007. Interestingly, in the United States, privacy from a federal level was pretty well baked by then. We had HIPAA, we had the Gramm-Leach-Bliley Act that affect financial institutions. We had COPPA, the Children's Online Privacy Protection Act. And it's been a pretty slow time for the federal government with respect to privacy laws. There really hasn't been much. What we have seen, however, is that the states have been the real drivers. And in 2003, we saw the first data breach notification law that went into effect July 1, 2003 in California, and really hit the national radar screen in 2005. And that has exploded since then. And I'm going to reserve that for the cyber piece. But that's a very important example of how the states are really driving the privacy and the security dialogue in this country. In Europe, we had the Data Protection Directive, which really was very much in flight in 2007. It came into effect in 1995. And we were very much struggling with it in 2007 and beyond. But the directive was enacted in the mainframe era. And so now, as of May 25th, 2018, we're going to have a completely different regime in Europe with respect to data protection. Data protection and privacy, same thing, by the way, just a different lexicon in the different jurisdictions. So we're going to have a completely different regime starting May 25th. It really, really changes the landscape, and it's very hard. And you know, we're all talking about how exhausted we are because there's so much going on in our world. The rest of the world, in 2007, we had some scattered laws. We had a data protection law in Argentina, for example, one in Japan by 2007, Canada. But really not too much else outside of Europe and the United States. Now, there are data protection laws in well over 100 countries globally, and just about any jurisdiction you can name has some sort of data protection law in place, and more likely a comprehensive data protection law like that in Europe. Government surveillance. So 2007 was pre-Snowden. It was pre-San Bernardino. There has been for a long time now a discussion by law enforcement authorities about the going dark issue, meaning they couldn't get at data that was encrypted. 2007 was sort of almost pre-encryption. I mean, there was some encryption, but I don't know. Did we have mobile devices in 2007? I don't think so.
We had Palm Pilots.
Did we have? Yeah, that's so. I just found mine recently. Actually, I kept it because I thought it was an interesting antique. So, you know, we really just didn't have this issue. It's a very, very important and significant issue now. And of course, we just passed the Cloud Act in this country, which allows US government law enforcement authorities to access data anywhere in the world that's maintained by a cloud host with a subpoena or a warrant. So very, very, very important shift there. Cybersecurity, well, that term didn't exist in 2007. We were talking about data security, data breach. We certainly weren't talking about cybersecurity. And, you know, we can sort of, I can trace all this because I kept changing the name of my team. So it was privacy and information management, and then it became privacy and data breach. And then, I don't know, 5, 6 years ago, I succumbed to the term du jour. We renamed it privacy and cybersecurity. So that really has come to the fore in just a few years. In the US, as I said, we had California, the first data breach notification law came into effect July 1, 2003. Now, as of just last month, we now have 50 state data breach notification laws, plus Guam, U.S. Virgin Islands, Puerto Rico, and D.C. So just about every jurisdiction. Do we have a federal law? No. Huge paralysis at the federal level for what should be a very obvious, you know, low-hanging fruit to enact a federal data breach notification law where we have 50 states that have them. In the EU, there was absolutely nothing in terms of data breach or security laws. Now we have the Network and Information Security Directive, which requires that there be a cyber guru in every country, and it requires activity on the part of companies to manage around data security. The General Data Protection Regulation, which is coming into effect on May 25th, is GDPR, has very significant provisions around data security, and for the first time, a pan-European approach to data breach notification, where we have to notify regulated entities, which is just about everybody, needs to notify within 72 hours of a data breach. It's going to completely change the landscape, and we're already gearing up and panicking just a little bit over a 72-hour notice requirement. We had no understanding at all of the different categories of threat actors that we're seeing today, and just to very quickly identify them, we have what I'll call traditional hackers. Sort of a funny thing to call them traditional hackers because it's only been a few years, but those are folks who are in it for pecuniary gain. What can they grab and sell on the dark web? Second bucket are nation-state actors. We certainly weren't seeing much activity around in the 2007 range, and whatever activity we saw from nation-state actors was sloppy. Then now, of course, enormously sophisticated, and almost all the breaches that not almost all, but maybe 50–60% of the breaches that I'm handling now, and I handle at any given time 5 to 7 breaches at different stages. Many of them are nation-state related, and they're grabbing intellectual property, they're grabbing M&A information, financial data, and of course sometimes personal information, but not so much. They're not so interested in that. They're interested in other things. Nation-states, traditional hackers, and hacktivists. Folks who are looking to embarrass, and we used to think of hacktivism as just having nuisance value, but it can also be extremely damaging. You know, think about Sony, which is nation-state, hacktivist, sort of balance between the two. Enormous damage can be wrought through hacktivists as well. So, and of course, the insider threat overlays all of this. Threat from vendors overlays all of this. Edward Snowden being the ultimate insider. And so we think about this now in a very different light. So 2007 was a completely different world in my world, but I feel like everything we've invented the wheel, really. We really truly have invented the wheel in this area. The handful of practitioners who have been doing this for a long time, and now we have a reasonably mature global regime that we're managing to every day with respect to compliance for our clients. So I'll leave it at that.
Well, thank you very much, Lisa. And Thomas, I have to admit, you made a comment to me right before you sat down that told me I was onto something, which was about this panel. You said, it's the first time you've spoken before a spec, you've been a little nervous. And I know as polished as you are, you don't really mean that. What I take this to mean is, I made you think. Because instead of the usual talking points we're on, it made you reformulate, and I think that's a really great thing. I'm delighted to hear what you came up with in those thoughts.
It's true. Well, maybe not so much, but we'll find out. Lisa's pretty scary, though, I'll tell you, with all that stuff. Well, 2000, it occurred to me, while the other folks were giving me a minute to gather my thoughts here, that, yeah, that was pre-Great Recession. So the Great Recession was a pretty big deal for us and for the industry that we're in. In particular, I mean, we didn't almost fail, but we literally had a deal that was closing. There was no reason for it not to close, but there was closing the Friday that Lehman failed, you know? And we sat around that morning because we needed cash. We had plenty of investments, but we needed cash. And I remember we sat around and said, well, what do you think? Are they going to wire the money or not? I mean, the deal had been signed and closed, and there was no way out, really. But we said, would we wire the money, you know, and just have a big fight? And it turned out they did wire it, and that solved the next 18 months worth of problems, because we really didn't do anything really for 18 months, and mostly the industry shut down in the Great Recession. I mean, venture and private equity, really everything ground to a halt while we figured out what was going on. It was a challenging time in that respect, mostly just to fall back and keep our companies going while that was happening. I was talking to my partner last night as I was on my way out the door. He's also a Penn Law grad, and I said, you know, Bob, I got thinking about this assignment, and I said, you know, everything has changed. I mean, there just isn't. I mean, I guess unless you're, you know, Amish or Old Order Mennonite, everything has changed, I think. You know, and among other things, I mean, we have, our portfolio has done great. We're still pretty much a traditional, I wouldn't say old-fashioned, but a traditional fund that invests widely. So we're in, you know, we're in life sciences, and we're in bathtubs and shower enclosures at the same time, you know, and there are not too many people that have the kind of portfolio that we have. We were in the publishing business a little bit, and I forget, is it Bill or William, but you, I think, had the scariest time of all, because we were in publishing a little bit in 2007 yet, and it was just really a nightmare because the entire world changed, you know, faster than you could change with it, really. It was really something. It was a little bit like the prior crisis, you know, where you had to get, first it was you had to get eyeballs, and then you had to get this, and then you had to actually get some sales, and the analysts kept moving the target so that you couldn't possibly keep up. And eventually we ended up with the big bubble before the Great Recession. I think in our case, some things have changed, and I think a lot of it relates to the internet and how much communication there is available. So we're talking all the time, except, interestingly enough, and maybe this was prep for today, I left my phone in my office last night. I was really hosed, you know. And somehow I got home without realizing it. And about 2 hours later, because I was trying to figure out what categories I could talk about today, I said, I wonder where my phone is. I've got to find that, and I've got to call somebody. So I went looking around the house in all the usual spots, you know, in the kitchen, you know, in the bedroom, in my briefcase, nothing. And then I said, okay, well, I'm just going to dial it up. Dialed it up, ring-a-dingy-dingy, but not in my house, you know. So then it was like, okay, and here's, you know, it was like, you know, find my phone, right? So pretty quickly that app, you know, finds everything I've ever had that talks to Apple. And it said, well, your phone's 13 miles away, you know. So it was interesting not to have it for an evening and this morning, particularly since a friend of mine from literally my high school class who I'd seen over the weekend showed up this morning, and I didn't have any way to tell him I was going to be late, really. You know? So I think the internet really has changed our business kind of how we do it and in terms of the volume of information that we have to deal with. I think it was probably about 2007 I said, you know, you've got to either stay on the traditional ways of communicating or you've got to switch to the internet. So I switched to the internet, and you know, frankly, it's a lot of work to keep up with the internet in my business. Too much work, really. I'm trying to figure out an answer for that. But we have things that have changed in our industry are, among other things, maybe these guys ought to be hacktivists, I think. There's got to be a term for all these investment bankers that'll throw deals at us, you know, willy-nilly, because we're out there and we're available. And we are open for business, but, you know, I probably have, I don't know, 200 or 300 sources of deals that now kind of know where I live, you know, and are pretty shameless about throwing stuff over the transom to see what'll happen. Now, we do want to see what'll happen, but what do we do with the volume of it? It's a pretty big question for us. And on the other side of that, I think the fact that we've moved to pitch decks from business plans is really helpful, because you don't have to read all those plans that we spent so much time with. You know, it's not 100 pages anymore. It's hopefully, well, it could be 100 slides, depending on who you get, but, you know, 20 or 30 or 50 slides. I really think that's been a big help in our business. Barbara's business is hurting a business I was on the board of at that time, because I was on the board of a knockout mouse company that had pretty much the whole mouse genome knocked out. And the business is still around when people need a specific animal, but basically you guys have killed, you know, which is good. I mean, so, because I figured for a long time, if God is a rodent, I am so hosed, you know, and you probably, it's the other thing, God was waiting for you guys, you know.
Or God is a bacteria.
Well, that's true. That's a bigger problem. And so, yeah, so let's see what else I had here. Yeah, I mean, operationally, things have changed a lot. And they've changed in our companies. We had one company at the time that was in the weather forecasting business and using some interesting technology. Because of how they moved that company forward in the last 10 years, they've amassed a huge amount of data that says if we have a certain type of weather, retail behavior under certain weather conditions. So we are hoping they have, you know, pivot is the magic word these days. I wouldn't say they pivoted, they've kind of rotated a little bit. And their target markets are big retailers who can figure out what they think the weather is going to be themselves. We've given up the forecasting part. But if you have an idea about how the weather is going to go, we can tell you what people are going to do in terms of purchases. So we're hoping that becomes a big data company and somebody comes along and pays a really crazy price for it in the big data world, because we're definitely for sale there as soon as we can. Right? Yeah, there you are. Hey, exactly. So.
Well, that's wonderful. So if I may, I'm going to ask all of you at least one question. But since I've got you, Tom, I'll still ask you. Now, you talked about the business and the way you're getting information. You didn't talk about analytics. You know, and I'm wondering, you know, so I'm, like everyone, I'm enamored of the Eagles, and one of the things they say is they're high-value, high-risk assets, like, say, a star quarterback, do you draft the right one? Or patent quality has become a huge issue. All these things that determine incredible value from mundane things like our beloved Eagles, the things that are absolutely critical to the valuation of the company. Has that changed?
Well, if you've got a big enough fund and you've got a big enough budget, it has. And sure, to a certain extent it has. Investment bankers have gotten a lot better at, you know, we can kind of outsource our analytics to them somewhat. And I think, you know, basically we do a lot of due diligence that we didn't do before because the data is available. So we can do that. Hiring, typically, we're probably more traditional than most. We are still typically using retained search firms that we have relationships with. Mostly because they'll put up with us, I think, you know, but we do a lot of that. Analytics are definitely important, but, you know, and let me just step back, actually, on the earlier stage stuff that I tend to do now a little bit through a couple of angel groups, there's really interesting research from Harvard by a guy named Paul Gompers, who was an Olympic marathoner at one point, actually, before he grew up and went to Harvard, you know. But his research shows that for the really early stage companies and risk basically what he says is risk is irrelevant there because you don't have enough information to really calculate anything that's worthwhile. So it's all what your gut tells you about the people. I kind of like that because it saves me doing a lot of work. I can just say, you know, keeps it pretty short. I'm for you, bud. Just make this work, you know. But there's definitely more information available, and we do pay attention to it.
So going back to you, Bill, one of the things that's interesting in the shift from, so I had the privilege to edit a book that had a chapter by David Nimmer. And his chapter had a very simple insight, which is you've shifted from a paper product company to an online services company. And his claim is it's no longer a matter of intellectual property, it's now a matter of contract.
Okay.
Is that correct? And if so, how has it changed what you do?
So it depends on which part of the company you're talking about a little bit, I guess, but that's probably true to an extent. So the data, I draw a distinction in my day-to-day work between sort of the data product side and more of the content news sort of side. I mean, like data is content, but basically on that data side, I do think that it really is driven, the IP side. It's interesting because we talk a lot in sort of layman's terms when we find that people are using our data and products and using our content, you know. Layman's terms, people often say, "Oh, that's our intellectual property. You can't use that. You know, that's our copyrighted material. That's that." And I actually have to sort of advise my guys. Well, it's actually a little tricky in the data space. You know, where data it doesn't really fall neatly into most of the traditional IP categories, and it's protected more by, as you're saying, it's really more NDAs, confidentiality provisions. You know, terms of use on our website, subscription agreements that say, you can only use this for internal use. You can only use it for, you know. So you're right. I mean, I think the license agreements and the terms that you use for those things become much more important in a way that, you know. And in fact, when I started, you know, in 2010, and we really were just starting to put these products together, I had one of the battles I had to fight pretty frequently when we would, you know, customers would call me up and say, you just. Unfortunately, I was the one who, you know, put the terms together that they then had to review and try to negotiate with us. But we, you know, it was because we were sort of building this online platform, and they said, well, wait a minute, 5 years ago, we used to get a book and there was no contract, you know, and there were no terms. And what am I doing spending all this time negotiating with you? It's the same stuff, and you're telling me I can't use it in this way, and you're telling me I can. But, you know, we all know, you know, this is not new stuff in the development of the law. I mean, it's, you know, with digital products, obviously it's a different risk. The chances that someone is going to photocopy our 1,000-page book of data and, you know, start distributing around their company are pretty slim. Yeah, they might share a couple of data points here and there. That's probably not that big a deal. But yeah, sure, you put it online and suddenly you have, you know, bots scraping our website, and you have, you know, all kinds of traffic coming in and just sort of unilaterally grabbing all our information and then baking it into their own products, and that's a problem. So yes, I would say in that way that is true. And really, you know, some of that there's other statutory, you know, protections, and that's a little bit in flux, I think, you know, in terms of, like, you know, you have Computer Fraud and Abuse Act stuff, you have state law, trespass laws, you have things that are not IP laws traditionally, but that are protecting a similar sort of asset, really. On the content side, we, you know, the sort of more traditional publishing, and, you know, something we still have some books and magazines. Sure, I mean, it's a lot of the same old stuff with, you know, cuts, cease and desist letters with copyright, and, you know, threatening people with statutory damages, that kind of thing. But I think where the shift has really happened has been on that data side.
That's fascinating. Now, Barbara, there's something you didn't mention. There's a little word which is always in my head when I think of your business, and that's myriad. 2007, there was no myriad. Now we have one. And I know everyone's got an opinion. I imagine you do too. How's that? Well, before, you know, there was the ambiguity, and we have the, you know, what has this really done to your part of the business?
So actually, myriad involves what's patent eligible subject matter, that you can't patent things like natural phenomenon or laws of nature. It actually really doesn't impact CRISPR-Cas9, because the bacterial system that was giving bacteria protection against phages We're doing something completely different with it. So the predominant claims that we're going after are methods of treatment, methods of gene editing, and there's nothing like that in nature. That's not what CRISPR-Cas9 was evolved to do. Also, in terms of the compositions themselves, the guides, the protein, those complexes are not found in the same way we use them. They're not found like that in bacteria. The Supreme Court, the case that is giving us a lot of problem, however, is the Lexmark decision. And what the Supreme Court said in Lexmark, they were looking at first sale and whether that exhausts patent rights. And this was a case about people reselling printer cartridges. So you think, well, what does that have to do with biotech? Unfortunately, it has to do with biotech, because one of the things that we do is we grant licenses to companies that make research reagents that they sell in the field. We would like to limit those sales in much the same way the software licenses used to limit, and say that you can use these for research purposes, but if you now want to make a therapeutic drug, you need to come back to us, Caribou, for a different license. And that's all up in the air after Lexmark. People are still doing research use only licenses, but we don't know if they'll stand up, and a lot of law firms are spending a lot of time trying to think of creative ways to avoid the Lexmark decision.
Well, Lisa, I may ask you a question. You may be tired of hearing it already, even though it's fairly new. I think I'd be fired as a moderator if I didn't ask the privacy person about Cambridge Analytica, the current, well, and I'll try to put it in a more constructive way than just beating on someone, which is, we see this tremendous political movement right now, which my natural instinct is to resist, which is, we can get in these excesses where there's some flare up and there's this huge bubble. What do we learn from this that's more constructive? Because you're counseling clients that are conscientiously trying to do the right thing, but they look at the problems. A client that lies to you about their data retention policies, and what the scope, what really in the long term do we take from this in the context of a company that's facing a potentially extinction level breach event?
I do think, and I didn't think this 4 weeks ago, but I do think there's an existential threat, and I hate that term. It's overused, but I think it's real. Why? We've been watching this area for years, and there is a change in tenor now. It is unmistakable. We have cared about our information for years, but we have never really understood as a society how our data is used. There is a trade-off. We do not get the internet for free for nothing. There is value that we trade to get free internet and to get free Facebook and all the other services that we get for free. And we are trading our data. And that has been acceptable. It's been an undercurrent. People haven't really understood it terribly well. I think there is a new understanding now, again, because it's front page of the paper every single day, and there have been so many data breaches. We're doing right now the Under Armour data breach, 150 million user accounts, and the Hudson's Bay breaches, Lord & Taylor and Sachs, and it's just one after the next after the next. So there is an understanding of the value of data that did not exist just a couple of years ago. And really, I think there was a sea change around the time of Target. It was when cyber security went from being an unknown thing to known to the general population. I really am sensing a shift in sort of the grassroots, and that's where our laws stem from. If there's a grassroots issue that or focus on something, then I think our lawmakers will focus on it as well. We used to ask the question, we still ask the question in the office about data uses. What would your mother think? Because if your mother finds a use of data creepy, it doesn't matter what the law says. And there is a paucity of law in this country around the use of data. We have very significant laws in the healthcare center for children's data, for financial information, but for many industry sectors, there's no regulation really at all other than some enforcement hooks under Section 5 of the FTC Act, which prohibits unfair or deceptive trade practices and others. But really, there's a swath that goes without, at least I'll call it, heavy regulation. And so we always fell back on the ethical. And, you know, that's the what would your mother think question. Is it okay to use data in this way? And if we do, we need to talk about it. We need to be transparent with respect to our uses of data. And this is how we counsel clients. I think that what we are now understanding is that we as I'll call lawyers and companies weren't transparent enough. Because there really wasn't a general understanding about the uses of data and the trade-off that we make as humans, as consumers, when we use the free internet. So I do think there's a palpable shift, and it's going to be very interesting to watch over the next few years.
I suppose interesting is good news for lawyers. So let me ask you to look back, not so much about the field you're working, but on your own profession. And I'll start with you, Barbara. I'm going to ask the question to you guys in two ways, which is one way I could ask it is looking back, is there something you wish you'd known more of or done more of in your training and your background that would have prepared you better? Or in a slightly more self-serving form of this question, in the CTIC programs that we're now doing, is there something you wish existed when you were a law student?
Well, so as I've told Christopher, when I was here at Penn, there was one patent law class. It was taught at night by a professor, or well, actually a litigator who came down on the train at New York. It was viewed as kind of a trade school class, so we slunk in at night, took this class. He came in on the train, it was all very clandestine. I'm not even sure I got credit for the class. So I am so thrilled to see what's going on here. I'm in Berkeley. Berkeley Law School has a very active tech transfer office or technology center, because it used to be that there were specialized law schools, Santa Clara, Franklin Pierce, these kinds of schools, and patent law was somehow viewed as beneath lawyers. And yet, as you're seeing, whether it's patent law or intellectual property, trade secrets, copyrights, all of it is so important to our economy. So I wish the center had been here when I was here. In terms of your first question of what I wish I'd known, I started out my career in patent law, and I actually wish that I had taken more business classes, whether it was here, whether it was as an undergrad, wherever, because there's so much of my industry in biotech that I think having more business classes would have been something that would have been advantageous. But when I was here at law school, for example, there were the Wharton JD MBAs. Most of us, didn't want anything to do with them. But there really wasn't a way to take kind of a business school light.
Lisa.
Oh boy, so when I graduated, certainly privacy was not even a thing. But I did choose the other thing of the moment, which was environmental law. So I was an environmental lawyer for a dozen plus years, which I loved, really loved it. And I just then, around 99-ish, had an interest in this new emerging technology called the internet that I thought might have a future. So I shifted over the course of about 3 years. It took about that long to really understand that there was a practice here, because it was so new. And I really did love doing environmental work. Environmental, by the way, there was no environmental law class at Penn back in the dark ages. And of course now it's a very well-established area of the law. With respect to privacy and cybersecurity, we have invented the wheel over the last, 2 decades or so, and we've done that just out of necessity. There weren't even textbooks on it. Now we have a few. There's one major textbook and a few treatises, one that we wrote in my practice, and but there's really still very little. It's still a new emerging area. It's really quite nascent.
Bill?
Yeah, I mean, I love the idea of the sort of dual degree stuff that you're saying. I think I've always had this kind of feeling that I might have gotten along with, sort of coding and that kind of thing before, but the ship had sailed by the time I got to where I was. So that's a tremendously interesting, and to me it seems like a very valuable thing, because now I've ended up doing a lot of work in software and technology, and I'm always, I like to think that I'm a quick learner, but I'm always kind of a step behind the clients who are kind of explaining, well, here's what it does and here's how it works, and I have to ask a zillion questions that they're kind of rolling their eyes when it would be great to have some of that knowledge going into it, I think. But I also, I'd echo part of what Barbara said too. I think some of the, I think it partly was my own choice when I was here, partly was what was offered, but I think more business-oriented classes, and you mentioned earlier taking some even, when you got your hands on sort of accounting or basic sort of financial literacy, how to just understand basic financial statement. These are all things that I sort of had to learn on the job later, that I think, I'm still definitely playing catch up on a lot of that stuff, and especially when you're in-house, I think that's something that becomes much more important than it would have been something nice to know earlier on. Yeah.
Well, Tom, it's a tough question for you because you're probably the most overeducated person sitting up here.
Well, I do wish I'd taken a bunch, and I'm not sure they were available, but it would have been nice to take some more life sciences, pharmaceutical development courses, which I didn't do. So I kind of learned all that on the fly, running a company and that kind of thing, where we provided lots of services. So a little bit more technical background on biotech would have been helpful. It still would be, actually. But, it definitely would have been. I would do that a little differently.
Well, so before I open up the floor, we have, in addition to the distinguished alumni and friends, we have a bunch of young lawyers in the room, or aspiring lawyers, if you will. And a traditional thing for an alum for us to ask alums is to give them advice, because I get a lot of questions about what the future holds and based on where we are. And what would you tell a young person these days in terms of what kinds of things they should do? Why don't we start with Lisa and come this way for a change?
Data is everything. It really is. It is the future. It's the greatest asset a company could have. So anything involving data is a good thing. I think the other just piece of advice, and this has nothing to do with law, but I counsel my children who are 22, 20, and then I have a 10-year-old. But for the older ones, I tell them to pull every thread. When you are trying to develop into some area, there are lots of threads that are hanging from the spool. Don't let some of them drop. Pull every single one. You have no idea which one is going to lead to the next opportunity. So it's really important. It's exhausting, but it's really important to pull every single one.
Tom?
Well, I think, for me, we at one time or another have used lots of lawyers. So I think the ones that are the best to try to understand our business and get some idea about the personalities they're dealing with, mine or my partners or whatever, and what we expect or what we'll put up with or how crazy we can make you, whatever. And these days, I think it's probably a little boring, but there's a couple of folks we deal with on the Sarbanes-Oxley side, who well, why do I use them? Because I don't want to do that really boring stuff, right? So I'm not praising the content matter so much, but I'll tell you what, there's life there, and they're really good. They really help a lot because there are a lot of things that I think are appropriate that we've got to do now in our public boards. That we're probably not going to get through it all by ourselves, so they're very helpful there.
But has SOX changed things that dramatically? I've been told when offered board positions is if you're an attorney and one of the independent directors say no, because you just you're put on so many responsibilities, litigation, everything. It terrifies me, actually. And it makes me worry about board compositions too, because we need some expertise. It just seems like a big ask.
You mean where you're concerned that you would end up being the go-to person for those topics?
I've been told that if you're a trained attorney and an independent director from the company,
Yep.
there's all these roles, all the dirty work that has to be done by the board, all the problems. You don't get to make grand strategy, you get to clean up the messes.
Well, yeah, I see why they would say that. I think you just have to tell them up front, look, I'm not that guy.
Yeah.
I'm this guy, I'm not that guy. It is true. I mean, I don't know if there's so many where you need to be a lawyer per se, but the audit committee chairman is a big issue these days. So for instance, my partner and I would both qualify, except for the fact that our fund owns not a majority, but we own a huge piece of this one company we're on the board of. So I think we can be on the audit committee, but we can't chair it. So we've got to find somebody who meets all the hurdles, jumps all the hurdles that you need to jump. And in that case, it usually is an accountant, but the proxy firms will pick on you, and so yeah, I think it's just a question in a sense of setting boundaries. And it is true, if we have any litigation or anything on our public company, we route it to my partner who's chairman. He can handle all that.
Barbara?
So I think my advice would be to, when there's an opportunity out there, seize it, even if you don't think you're ready for it. For me, I had been a patent attorney for 12 years. I actually was heading up a patent department. The company I was at, a biotech company, publicly traded, the CEO decided to take the company private, but forgot to tell the board that's what he was thinking. And so, as you can imagine, that didn't go over well. Actually, it was kind of a coup. The CFO and chief scientific officer went to the board and explained the situation. The outside counsel was out, the CEO was out, and so the upstarts came to me and asked if I wanted to be general counsel. I had no idea what being general counsel was. Sarbanes-Oxley had actually just gone into effect, so I kind of figured, well, everybody's going to have to learn this new regime. I might as well learn it at the same time. So it was really a stretch for me. I've now been, chief legal officer at different companies for whatever that's been since that time, 19 years or whatever. But if there's a way to build in a safety net when you do that reach, that's great. Because one of the things I asked the then-to-be new CEO was, what if I don't like it, or what if you don't like me in this role? Can I go back and head up the IP group? And they said, absolutely. The board said the same. Let's give it a try. So if there's a way to build in some kind of a safety net, that's good. But I would just say when those opportunities come, grab them, even if you don't think you're ready, because chances are you can do it.
Bill?
Yeah, I think the thing I can think of is probably reinforces what I take to be a big part of the mission of the center in a way, which is just be practical, understand the business that you're working with, the organization that you're working with, and it doesn't necessarily apply to everyone, but if you're at a firm and if you're in-house, I think I was in law school at a time when things were still, tended to be very more theoretical, more substantive law, and it was you have this rough transition sometimes when you get into practice where you show up and, they say, oh, the client has this question, here's this thing, and it comes to you in an email, and you say, okay, I'm going to go off to my laboratory, and I'm going to write this thing, and you're proud of this memo that you wrote, and it's great, and it's all put together, and it reads great, and it's, this great analysis thing, and the client says, right, but what do I do? Exactly. So, it's not really, so to me, a big part of it is just, you need to have those skills, you need to use those skills, but a big part of it I realized as I went along was, it's really understanding, if you are outside counsel, understanding what really is a client trying to accomplish with this deal, what are they trying to accomplish more broadly, and then when you're in-house, obviously even more, you're more integrated with the business of the company, and that way you can sort of, your advice can be a little bit more practical, and then that, I have found that tends to be, on both sides of this, I've found that it tends to be what people internally are very happy to get when they get advice, and I certainly on the other side, when I get those memos like that, I'm like, thanks a lot, we just spent however much and I still don't know what to do, so yeah.
That's great advice. Well,
let me just say, the other thing too that just occurred to me is, I think the people that I know best that are my friends who are lawyers who are available when I need them tend to be the folks who've taken a lot of time to network outside of work into different entrepreneurial organizations, and there are tons of them in Philadelphia now. So, you've got to have you've got to have kind of the right attitude and be willing to sort of put the time in. But 10 years down the road, you may be the person with the slew of clients and other people working for you on the clients, if that's what you want.
Absolutely. Well, I could ask you the questions for the rest of the time happily, but I at least have to, and I will if none of you ask questions, but I would be remiss if not giving the audience a chance to ask this very distinguished panel any questions you might have about the profession or about the subject matter. We're also interested in the technology stuff. I do have one request. We do have microphones in the back because we do have an audience watching in on webcast. It would be ideal if you could actually make sure to speak into the microphone. Well, and I know Penn Law students are not shy. I know Penn Law professors are not afraid to call on them. This high-tech thing is called an on switch. I'm still working with this. Huh?
Hello.
Yay!
There you go.
Hi. This is for William, I think.
Yes.
Can you tell me a little bit about what you've done to maybe get caught up to speed in some of those conversations with more, I guess, technical founders or coders, or when maybe you don't have the technical background? Because the MCIT program also didn't exist when I was here. So how do you kind of bridge that gap?
Sure. So I'm helped by the fact also that, what we do at my company is not the highest sort of, it's not extremely high tech. We're mostly building websites and data products and that kind of thing. So it's not, but I still, putting together things like our policies on open source and putting together, different policies to protect our IP. That's usually when I get into those conversations. So it'll be a mix of more transactions where I'm, let's say, negotiating with the tech vendor, some platform we're going to use, some software we're going to use, and doing that policy work. And really, it's almost has a Socratic method aspect to it, I feel. Right? It's kind of like, or maybe it goes back to the pulling at the threads, right? It's like, the question, it generally comes to me as a question, okay, we want to get this contract done for this, with this vendor, and I sort of look at the contract and I say, some of this is Greek to me. Some of this I understand, but I'm not really sure how it fits in. And it's literally just kind of, usually sitting with, I have to find out who the right stakeholders in the company are, who's running this business, who's actually working on the technical side, who's working on the business side. But for each of them, I end up just having questions. It's like, I start at this level of generality way up here, right? And I say, what are we trying to do, right? What are we trying to do with this thing? Okay, it's an artificial intelligence sort of piece of software that we're going to be plugging into some data program that we're using. Okay, what sort of data is it working on? What is it that we're hoping to churn out and feed to our customer? And they kind of give me that answer, and then that'll sort of inform the next step. Okay, well, wait a minute. So where is the data that we're feeding it? Where is that coming from? And it's really just kind of this method of, step by step sort of following along, and getting the right audience to answer those questions for me. So the business guys, you know, that it's taken me a long time. Luckily, I've been in my company long enough now. I know who the folks are, but at first it was certainly very confusing. Even after our acquisition, you know, there's a whole host of new people, but I'm asking the business guys, well, on the technical side, how does this software work, and where, you know, where does the code sit, and where, you know, where does this, which database is this, you know, is this data in, and how are you using it with this? And the business guys are like, I don't know. It's fine. It's all it'll all work. They just want me to kind of get the deal done. So that's where I have to ask some questions and make sure that I actually get to the tech team who's working on that. And we, you know, there's luckily, you know, the company now is big enough. There's kind of like a whole support system in place as well. So there's kind of our tech team has a whole diligence sort of questionnaire process that they go through when we work with a lot of these vendors, and that I have found we didn't have that at Penton, and we have it in Informa now, and that's extraordinarily helpful to me, because it sort of gets rid of that, you know, I'm starting at this level of generality, usually lets me start around here, and then I can kind of dig into the specifics. I don't know if that answers your question or not, but it's hopefully.
Well, just to everyone else, you have to tech up too. I mean, all of us face these problems. How does a person without the background we wish we had, how do you deal with it?
Well, so in my case, I actually, before I went to law school, I was all but dissertation in primatology here at Penn, and now I'm in biotech. So that was quite a leap. And it's the scientists, for me, are my best friends, and I just pick their brain all the time. It's, in a way, one of the attractions for patent law to me was it allowed me in some ways to stay in school forever, because you're always learning the latest and greatest technology, and you don't have to do the work. You get to just listen once all the hard work's done. But it's just continually talking to the scientists, picking their brain. It's one of the reasons I like being in-house, because as outside counsel, it's hard to get a client to pay for teaching you biotech.
I'll just say, you know, when we graduate from law school, we are so smart. We're the smartest people in the room. And then we get dumber and dumber as we go out there into the world, and we realize how big the world is and how little we know. The thing that really always strikes me about first and second year associates is that they're terrified to ask questions. And when I started to do environmental work, and I have zero scientific background, zero. I was an American colonial history major in college. Key is don't be afraid to ask questions. And, you know, whether you're asking a hydrologist, when I was in the environmental world, over and over, please explain, and drill down. And now in the data world, I need a lot of explanation about technology and exactly how the data is flowing. I need to know exactly how it's flowing to provide appropriate legal advice. So that means asking 1,001 questions. And you know, people are very responsive to that. Most people like to talk and talk about what they know and love, and then we are in a position to provide more effective legal advice.
Anything?
Oh, me, huh?
No obligated.
No, I think I'm a little bit I'm still in school phase, you know, so I really still like really early stage ventures, and I feel like I'm in learning time all the time.
I'm all in favor of staying in school forever. Go ahead, Lauren.
Thank you. Hi, I'm Lauren Steinfeld, and I am the privacy officer here at Penn, and I'm just so delighted to be here. And thank you, Christopher, for hosting it, and all of you for being here. And my question was going to be, you answered part A of my question before, which was the fact that this is so complicated and so important, and how do you make good business decisions in the corporate world, perhaps not knowing all about technology, but I think you've answered that. You get the experts to really have good dialogue. Then I have sort of a couple related. One is, how are we doing at the legislative policy level on this? Meaning, are there people who are making big decisions about laws or not laws, et cetera, who don't have the background about this complicated area, and is that getting us into trouble? And then the other end of the spectrum is, how do we explain this to consumers who we're trying to get more knowledgeable and more in control of what's happening to their data, when it's harder and harder for even the most sophisticated business people and well-resourced companies to understand what's happening? So there's a lot in there. Take whatever piece you'd like.
I can try the first crack at that. I know your name very well, so
I know
it's
yours,
really,
and I'm so
really a
happy.
pleasure. So there's a lot of talk right now about pale, male, and stale. You know, old white men in Congress are having to learn a whole different vocabulary, and I think it's very, very challenging. We are seeing some shift, like at the FTC, there's now a chief technologist. That's only happened in the last couple of years. Now at the SEC, there's a cybersecurity division. That just happened in the last few months. So these are folks who are now, for the first time, really bringing this new expertise to bear. I hope that will rub off on the legislative process, but it's a big challenge because there's a huge lack of understanding, really a paucity of knowledge. How do we educate consumers? We're getting there. So there are some agencies like the Federal Trade Commission that has a big educational mission to help people understand how their data is used and protected. It's very challenging to get the word out because it's complicated. It's not easy stuff. How do you reduce it to a really understandable nugget? But I think the media also plays a huge role here, and it's so critically important for press to push articles like how to protect your data, and what does it mean to have a free internet and trading your data for the free internet, and things like, as much as there are so many issues involved with the Facebook issue, but it really is having an educational component to it. So there's a very different understanding now by the person in the street about privacy and security of their data than there was 10 years ago, and it is the world we live in today. So hopefully, as a society, we will educate each other, and in 10 years we will have a whole different discussion. But it'll take a long time, I think.
Thank you.
Good question.
In my field, and especially located in Berkeley, California, as you can imagine, we have the anti-GMO people. Everybody's got their fears of designer babies and all the rest. And I think initially biotech took the attitude of, they're uneducated, we don't have to talk to them, and they discounted them. And then we've seen legislation go through because people don't understand what gene editing is and what it isn't. And so there's been a recent effort to engage with a lot of the more citizen-oriented groups and to use examples. For example, if you could have some kind of crop that was drought resistant, and that could be grown in India, or if you could have something so that you weren't spraying herbicides and dangerous chemicals on crops, and to actually see that there isn't a world of GMO and non-GMO. And actually, it's interesting because the US Department of Agriculture, who regulates crops, has said that CRISPR is not gene editing in the sense of a GMO because we don't insert foreign DNA. And so, I think you need to engage with the groups that are out there and just make sure everybody's coming in with the same level of knowledge. I heard a Nobel Prize speaker one time who was urging a group full of scientists to publish in airline magazines. He said, forget science, forget nature. You need to be in the airline magazine because you need to teach the public what it is you're doing so that we don't have laws for, forbidding something that is actually very beneficial to humans and to the planet.
Yeah, no, the legislative side I don't know a lot about, but some of what Lisa was saying before I think definitely resonated in terms of, I think it does seem to me that the day is coming pretty soon, and certainly these hearings with Facebook are an indicator as well. Just from the discussions that we have negotiating these deals when we work with our platforms that help us collect data on our users and help us track users and help us do all these different things that are collecting the sort of data that's at issue here. For the last several years, those negotiations were frankly, a lot of us, we're trying to figure out how it works exactly, but just kind of having to do our best, having to make these things work on the fly. And there was a lot of sort of land grab, provisions in these things. Well, we have these rights to use the data however we want, and you're giving us ownership of all this data, and no one really knew what it meant. Everyone just wanted to kind of stake their claim to as much data as possible in case it was useful at some point, right? So I do think now the conversations have gotten a lot more sophisticated, even just the parts that I see negotiating these contractual provisions. And that's happening within our companies too. And I just think at a more granular level, people are starting to understand, okay, this is what the different, different data points are. This is how we can use them. This is how this and that. And I do think it's taking time, but that is getting, and this is where you start seeing in the, social media networks, where you start seeing more granular choices in terms of you get to make a decision as to what you're sharing and what you're not sharing to an extent. But I do think that progression has got to continue, and I think we're sort of now at this moment where people are kind of focused on it. I think that'll probably push things along down that line a little more, where people, my hope would be that, there can be sort of a more sensible, less land grab sort of style of we're just going to take all the data and use it how we want, more sensible, like, okay, we're going to help, advertisers to be able to reach you in a sensible way that also does not make you feel creeped out every time you check your email or something.
I sat on a panel a few years ago with a big data analyst, and she said, I take data the way I buy shoes. Every size, every color, every style. I just want it.
Right, exactly. Dave.
Thanks to the panelists for sharing your wisdom with us. So I think this question is primarily for Lisa, but it could be for everybody as well. In a lot of the work with privacy and data security, it can have the feel of preventive medicine and compliance work in advance. And then all of a sudden, we threw around the word extinction for Facebook. An extinction level event could occur to a client. And that is, it seems like a difficult relationship between the advisor and the client, where it's not a profit center. And you want to advise them on how to avoid the extinction level event, but also prepared them for dealing with a breach when it happens. And I'm wondering what tools you bring to bear and how you think that process is developing as clients learn about this becoming a possibility for them.
Yeah, I think a couple of things here. We really do think about ethical obligations in my area, and I'll just give another example for Facebook. So I'll put Hewlett-Packard in the spotlight for a minute. A number of years ago now, there was a board member who was leaking information to the press, and they didn't know who it was. And so the general counsel at the time sanctioned a PI firm, a private investigation firm, to do what is now known, what was known then, but not illegal, as pretexting, pretending to be somebody they were not to get information. So you can pretend to be board member A and get board member A's phone records by pretending to be board member A to see who was speaking to the press. That was not illegal at the time, but it was an existential threat to the company. The chief compliance officer, the general counsel, many of the board members resigned as a result, and they sat in front of Congress testifying as a result of this. So that's the ethics question. And that, we really do need to focus where there is this dearth of law in an area, as there is in privacy. We have to focus on the ethical questions. With respect to preparedness, yes, we do a lot of it. It's really important. Over the last, say, I think 4 or 5 years, we've done a ton of cyber preparedness work, because we pretty much know that every single company is going to be hit by a cyber event, whether significant or not, they have to be prepared. So we practice a lot to build muscle memory. We make sure that every company that we're working with has an incident response plan in place. They have breach notification procedures. They have practiced a massive event through a tabletop exercise constantly. We have one client we represent who has done, I think they said like 126 of them in the last year. That's a little bit of they're a little excessive in their focus on this. But you know, doing a tabletop exercise annually with those who will have roles in managing data breaches, because everybody will experience one. So doing this sort of preparedness work, knowing what's coming down, truly inevitably coming down the pike, is so critical. So, you know, good point about making sure you're preparing for an inevitable event.
So, anyway, my instinct is we're pretty bad about the preventive medicine. I don't go to the gym very often, nor do I sleep properly. Anyway, Osaki, did you have something?
Yes.
You then, last two questions. Actually, well, if the audience, the online audience is going to hear, he has to speak through the mic.
Hi. I could have asked questions of everyone, but I'm trying to be mindful of time. So I'm just going to concentrate one question with a couple of levels to it, to Lisa. So your practice in the area of privacy and the like, and we've talked a lot about the internet. I think it would be helpful for the group to hear what percentage of the internet we actually have access to right now, because I think it puts into context how huge an issue this is. The second element there is, I think it would be helpful for people to understand, since you are dealing with what happened in the past, the impact of the web browser and how that fundamentally changed the world that we know. And my third and final question, it has to do with the question of, since so much of the internet is the darknet, and in light of what is happening in the portion of the internet that we do know of, such as this Facebook situation, do you expect federal regulation?
I'm going to start with the last. I testified before Congress in 2006, and it was a time just after, it was probably around June, I think, and it was just after a hard drive had been stolen from the home of an employee of the Veterans Administration with 26.5 million veterans' information on this hard drive. And the question was posed to me, did I think this was the event that would drive federal legislation around data breach notification? Remember I said there are 54 laws in the United States, 50 states plus the 4 territories around data breach notification. And I answered, absolutely. This is the cataclysmic event that will drive us toward federal breach notification legislation. So I have 0 powers of prognostication, clearly. But let me be a little less glib. I think there's a chance now. I've completely dismissed the chance of federal privacy legislation over the last many years, where there have been many bills, lots of people are making a lot of political hay over privacy legislation. I think there's actually a chance, and I think the states, again, the states will lead probably on this, but maybe the federal government can come together. Maybe, of course, the devil's in the details, and that's where everybody stumbles. So we'll see. But I do think there's a change in tenor. So we'll see about that. So I mentioned some of the other, I'm going to turn to your web browser question. I mentioned some of the other breaches that we're working on. What we did last year and what I spent the better part of my life on was the Yahoo data breach, which affected, a number of them affected in total about 3.5 billion user accounts. So there were, 7 billion people in the world. So very significant issue. Yahoo, was the first, or I think was the first, or among the first, And it's very interesting to see where companies have gone who were really first in this space over the last few years. But so much of what we're doing today and what Google and others are doing today in this world comes from those very, very early days and those incredibly prescient and brilliant people who created what we now know as the internet. With respect to the dark web is fascinating. It's a place we don't go, and I have only gone there when I've been shown pieces of it by law enforcement, because it's a little disconcerting, and we don't really know how to get there ourselves unless you're trained in this. But it is where much of the criminal world trades their wares, and it's used ubiquitously now. We hire companies often to go into the dark web to see if our clients' data might be in there, but it's the unindexed web, essentially, for those of you who are not familiar with the dark web. And there's the deep web and the dark web, and they're not necessarily the same thing, but it is in the dark web that the criminals play, and so much of it is actually not in English. It's in Eastern European languages or Chinese, Asian languages as well. So it's a pretty interesting place. I would not suggest going there.
Last question, please.
Good afternoon, everyone. My name is Lena Cassie. In regards to data, this question is really towards Lisa. Data. So do you think the blockchain's transparency will change the way private data is being managed nowadays? For instance, StemChain opens up the transparency for donors so that all records are open on the blockchain for everyone to see. But there are talks about putting health records on the blockchain. Will this impact HIPAA regulations?
HIPAA came into being around 2000, and the regs came out just 2001, 2002, 2003. Just after that, it is ancient in the world of privacy regulation. But it's interesting. It's probably the most comprehensive federal law in the privacy space, and really, and it's really the regulations, not the law, that regulates in the healthcare sector, regulates privacy and security in the healthcare sector. But it is really old, and nobody's going to touch it because the left is afraid it's going to be moved too far right. The right is afraid it's going to move too far left, and this is why we're a little bit paralyzed in this space. The Privacy Act of 1974. Anybody know why the Privacy Act of 1974 was passed? What happened in 1974? Don't answer that, Milo. Watergate, right. So it is the basis for privacy law all over the world, but it remains to this day. The Privacy Act of 1974 hasn't been touched, and it affects just the federal government. It's really an extraordinary thing that it hasn't been touched since 1974. Blockchain. I think there is an enormously bright future for blockchain. We haven't quite figured it out yet. It's an area that lots of people are spending lots of money trying to be the first mover in various areas of blockchain. I think it's going to be, it is very powerful, of course, with respect to cryptocurrency and other uses now, but we ain't seen nothing yet. It's going to be a very, very interesting area to watch. So I would recommend watching that area. And that's, as I said, data is everything, and that's, there it is. That's one area that I think is going to be fascinating. And fintech is of course, very focused on blockchain, and we're going to see a lot of movement there as well.
Thank you.
Well, we've reached the end of our appointed time. I would like to please join me in thanking the panel for the scintillating conversation. We will now adjourn until 3:30, where we'll resume with our second panel. Thank you all for joining us. And there's coffee out there. Excellent. It is time for us to begin, but Osagi, who graced us with a question earlier, is not quite here yet. So we know he's here. Excellent. Yay. Well, anyway, we're delighted to have everyone here. It's been a lot of fun, I think, and really quite interesting. I'll get a chance to look backwards. Well, in this case, I guess this is what my friends used to call vamping. when you try to do this. I will take the time to actually introduce more properly our panelists while we're waiting for Osagie to come join us. We had the last panel was to look backwards over the last 10 years. This is hopefully the far riskier and far more speculative exercise of looking forward. As I mentioned to someone here, predicting the future gets extremely hazardous. I stopped doing this after the last election. But let's just say I think we have people who can at least helpfully give us some enlightenment, or at least some more informed speculation about what the future may hold. The person, just to introduce them, to my right is Milo Cividanes. He's a partner at Venable, again, in privacy practice, and an area where, again, we had to explain what that once was and are no longer really have to do that anymore. 3 decades of experience counseling clients on privacy and data security, has served as counsel to the U.S. Senate Judiciary Committee Subcommittee on Technology, been in private practice, and is an '83 graduate of the law school. We're so proud, as we are proud to acknowledge. Osagie Imasogi, senior managing partner and founder of Phoenix IP Ventures. Currently, he was the co-founder of many different things in the tech space and established the internal incubator for GlaxoSmithKline, and has become an expert in many things in the healthcare field, but also has a very keen understanding and strongly held opinion on patents. Teaches a wonderful class here on intellectual property and national economic value that our students love dearly. He is a great friend to Penn and the university level, and being one of our trustees and a friend to Penn Law, and we're delighted to have him here. And in the future, looking, if you want big, expansive ideas, I always learn to turn to Osagie and ask him to think. And then our last panelist today is, not last, but I mean the third one I'm introducing is Gary Songha. Gary is heads a company called LexCheck, which I would say is how technology, AI-based technology, is going to change the practice of law. To clarify a little bit, he's not one of the companies that's trying to replace lawyers so all of us can breathe a little bit easier, but it is trying to harness the value of AI to the benefit of lawyers in terms of how they practice and seeing how that functions, and more importantly, has some interesting views that we started to discuss based on the problems, limitations, and the need of a proper understanding of AI and its proper uses. And so we're happy to have his perspective, because it's fairly clear that AI is a growing part of what all of us do every day. So I'll just start with you, Milo. We've heard about the past. We're now supposed to be looking into the future. Let's start with the short run. We'll save the moonshot stuff, but okay, let's just say in your field, in recent weeks and months, we've probably had more stirring of the pot than we've had in a bit. What do you see in the immediate future that's going to happen in the privacy space, in the security space? Anything exciting? I mean, what do you make of all this?
Well, it's some of it's deja vu, but some of it's real. I think some perfect storm elements, put aside the Facebook Analytica issue, which is saying a lot, but there's a reference to the European changes that are taking place next month, which the Europeans have in the past tried to influence US law. They tried this 25 years ago. It didn't play out exactly the way they had hoped. This is different. There's penalties, there's other aspects here. And as Lisa referenced, there's the state issues. There's a ballot initiative in California. So you've got a number of elements going on here where there could be a push. It could start as a call it whatever you want, a fire in California. It could move. A year and a half ago, I was asked to forecast, like you, related to the elections, but I was asked, and I painted a scenario in which I thought that we could have European-style privacy here in the United States, but the path wasn't through Congress. The path was essentially there was the Federal Communications Commission rule that was making its way. And then when business throws its support for legislation, we tend to see legislation. It's more likely to happen. And so I could see, a scenario where you had the telecoms now harnessed and burdened with certain European-style legislation, restrictions, asking for a level playing field, throwing the support for federal legislation. You could see something like that happening. That came to an end with the election of President Trump. So I never say never, but I think it takes a lot for certain things to happen. But one of those is action in the states. 15 years ago, in terms of email marketing, there were discussions. California passed the law, and business went straight to Congress and said, we need a preemptive federal law, and that was passed. Now, that was one specific issue. It's much more complicated when you're talking about privacy and certainly across all fields. I can come back later to some of the institutional challenges Congress has for passing legislation in the privacy field that's European-like. But I certainly agree that there's a lot of stimulation taking place, a lot of, but it's going to take, I think, more than what the congressional hearings are taking place. But unfortunately, there are some of those stimulants out there. So we could see some things coming together. The contours of that, again, worth discussing later.
Sure. Osagie, future.
The future. The future. Two things before I make my comments. The first one is, I always say to my students that, prior to your conception till after your death, the law governs you. So what is amazing is that no matter what the future holds, it's going to be within the context of law. Law is the ground norm, as it were, within which we run our societies. The second thing is that when Chris asked me to join this panel, the good news was that he talked about only 10 years. Because that allows us to avoid the moonshot questions. Because 10 years is tomorrow. It's literally happening.
Although the moonshot took less than 10 years.
That is true. But things have moved much faster now than ever before. So I was glad that I could limit my thoughts to 10 years. And my third and final comment is that it's always fascinating when people ask you to talk about peeking around the curvature of time and space. It's sometimes challenging, but I have attempted to do that for what it's worth. So from my perspective, there are probably four major things that I think are going to affect the law, or that the law will affect as we think about what's happening in the next 10 years. I'm very glad that Gary is here, because the first one is AI. I think AI will have a profound impact, and it's already having a material impact, maybe not profound yet, but a material impact on how we practice law. It is taking out what was pretty much routine work. There was an article that came out some time ago with the big heading, JP Morgan software does in seconds what took lawyers 360,000 hours to do. So the reality is that companies like Gary's, companies like Kim, companies like Ross are already providing a platform that allows a fair amount of work that first year, second year associates, maybe even third year associates used to do and get paid for very, very handsomely. And now you've got an AI doing a fair amount of that work. That has an immediate impact, and that impact will grow over the next decade. And it has an impact as to what we do as a law school. How do we train our students? It has an impact as to the job description. What do you do if you are a first-year associate? How do you ever get trained? And it has an impact as to how the practice of law interacts with its clients. So I think that's going to be a big issue, and we can talk about that if anyone wants. The second one, unfortunately, Barbara has left, is, in my view, the whole issue of CRISPR. And the importance of CRISPR is, in my view, very similar to what the web browser ended up doing to what we call the internet. Prior to the availability of a ubiquitous web browser, you almost needed a PhD in programming to be able to send a little note through what was the nascent internet. What made the internet available to the vast majority of people, and what made it commercially a source of tremendous wealth, was the fact that the web browser was developed, and you could, in plain English, type in words, and all that programming happens in the back. You don't see it, but that allowed people now to interact and use the internet. I'm of the view that CRISPR might be a similar kind of event with regards to gene editing. Now, why does this affect the law? Well, if you can, in a ubiquitous manner, edit genes, it means that there is a possibility that you could end up editing genes that go into the human genome. And the minute you do that, and people then reproduce with the edited gene, you are self-directing evolution more often than not. And that's going to have a profound impact. It's going to have a profound impact as to what it means to be human. It's going to have a profound impact as to how we, in the law, treat the ramifications of this tremendous power that is already out there. And, you know, they're very smart high school kids now, and I would tell you that some pretty smart high school kids already have the understanding of what it means to use CRISPR. So I do think that is going to have a profound impact in the future. The third thing I would say is the whole issue of life extension technologies. Now, I'm not talking cryo, I'm talking life extension technologies. There are folks already out there who, one of the leading proponents is Aubrey de Grey, who take the view that aging should be viewed as a disease. Let me repeat that. That aging should be viewed as a disease, and like all other diseases, we should be thinking about how do we treat it. And if we, instead of talking about individual organs and individual concerns, let's think about it holistically. And if we do that, then there's no logical reason why our lives cannot be extended into the hundreds of years. Now, this is not cryo. This is just life extension technology. Well, you might think that that is science fiction, but there's a company that the folks in Alphabet started in conjunction with AbbVie. They've put $1.5 billion behind it. It's called Calico. That's real money. There are a host of other folks who are backing different companies that are focused on this issue of life extension. There's a huge 6,000 patient study ongoing right now on geroprotectors, essentially certain drugs that are already on the market, already commercialized. In fact, the lead proponent is off patent, that people think could help protect cell life and help extend the division of cells without it becoming cancerous. So, to the extent that this technology continues to evolve, in the next 10 years, we're going to have an interesting question to wrestle with. What is the average lifespan? What does that mean? When this country was founded, the average lifespan was roughly 40 years. All the so-called folks in history, Alexander the so-called Great, did everything. It conquered Europe and Asia by 36. JC killed over at 36. The average lifespan in the US now for men is roughly 78. For women, it's roughly 79. We men kill ourselves much quicker. But what if your average lifespan is 150? I'm talking an average now. What if it's 200? What if it's 250? What does that mean to the law? What does that mean to estate law? How do you plan for that? What does that mean to matrimonial law? You're going to be married for 250 years? Really? Same person? Really? What does that mean to employment? I mean, fundamental shift in terms of how we see the world. And I will mention the fourth and final one. And by the way, there are a whole bunch of companies that are focused on this right now. Osin Biotechnologies and the like. Calico is one I like a lot, Unity Biotechnology. And the fourth and final one I would mention is what is happening right now in a number of our leading universities with regards to the issue of neuroscience and brain mapping. So two different angles there. There are those who are working very hard, University of Southern California, for example, on trying to download the human brain. Interesting. What happens if you do that? The moment that downloading occurs, what happens to you? Is there a second you? And if that second you, is that alive? Is it alive? What happens if you decide to switch off the plug? Does it die? What happens to the question of property and inheritance? Does that second you own part of your 401k? Up to the point where he was downloaded? I mean, what do you do with that? Okay, significant legal issues we have to think about. The second part of that angle right now, Stanford is doing a great job, and a whole bunch of other universities, on the question of the human consortium program. So there's serious work being done on these issues. I think in the next 10 years, we're going to start getting some manifestation of this work, and I think that's going to have a profound impact on the law. So I will leave it at that, but I think there are at least 4 issues that kind of struck me that will be very crucial in the next decade, and I'm ready to discuss ad nauseum on each one of them.
Sure. Gary.
Hi, my name is Gary Senga. So I've been in the legal tech game for 10 years, right? I'm a serial entrepreneur. I had the largest legal tech acquisition in the last 10 years. It's my second startup. So, I'm the one that's supposed to say, hey, we're going to change the world tomorrow and watch out, right? It's not happening. I don't think the law is going to change that much in the next 10 years. And I'm the disruptor. I'm the one that's going to do it, right? And I don't think it's happening. That doesn't mean that the world's not changing. That doesn't mean that there's not cool technology. And by the way, so my latest startup, we're working with the computational linguistics department at Penn, which are, a gazillion times smarter than me. So we talk about these issues. And by the way, what we don't appreciate about AI, don't appreciate about, neural networks, all that good stuff. Yeah, the algorithms are cool, but you know what the real secret is, by the way, folks? These chips have just gotten better. Moore's law is actually the unsung hero for so much of this innovation. It doesn't get much credit. No one gives Intel a high five, but it's actually just the hardware's gotten a lot better. But I digress. There's a lot of cool stuff happening in the world. It's not going to impact legal that much. It's just not. There are 2 reasons for this. So again, as a legal tech guy, I get pitched by entrepreneurs, law students, lawyers that want to get into the sector at least twice, maybe 3 times a month. And I take every meeting because I believe in karma. And what people don't appreciate, so they come in and say, Gary, here's my idea, it's sick, I'm going to apply all this cool tech, wow. What they don't appreciate is that legal tech and involving tech in the law is fundamentally a sales and marketing game. And you're trying to sell something to a buyer that doesn't want it. I bet you a nickel, if you did a poll of senior partners and you asked, would you rather go back to the world 20 years ago, I suspect a high number would probably say yes. I don't think most, but I think a high number actually would, if they're honest, say yeah. I say most. Yeah. I think, so literally, I have technology that I now have to push on someone that doesn't want it. Just think of the challenge of that, right? Think of the challenge. So which makes it incredibly challenging. I can go to an intelligent person, Ivy League educated, top of their school, but any metrics, brilliant, and I can explain ROI. I can explain Pareto optimality. I can explain efficiency. They're like, yeah, whatever. Like, they conceptually get it, they don't care. It does not impact their purchasing decision-making whatsoever. It does not impact it whatsoever. So, okay, so Gary, how have you been successful? How have you done this? You know what drives legal decision-making? As someone that actually has to push products to lawyers? FOMO, fear of missing out. I have to get the lawyer that the other lawyer looks up to or is threatened by, I have to get him or her on board. That gets the other lawyer on board. That literally just human emotions, what the pretty girl is doing is actually what drives decision making. Not a complex spreadsheet about ROI and the value I give you. Okay, why is that? And that's a separate panel altogether, right, in terms of what's broken in law. But fundamentally, you know, when you talk about tech, I run into the Terminator problem, I call it. So the Terminator problem is people see me and they see the machine coming in from the future and just taking out everybody in their jobs, right? It's not even like in the back of their mind. They just say it straight up, right? They just say it straight up, yeah. Like, you're gonna take my job away? I'm like, not yet, but maybe. You know, so I gotta sell someone the task of being automated. Just look at the challenge of this, right? It's like trying to feed kale to a lion. Like, you can try, but it's like, and then, you know, so then people say, you know, but my tech is so awesome. It doesn't matter. You're trying to feed meat to a vegetarian, and this is, it's incredibly challenging. So the world that when I practiced 10 years ago, it hasn't really changed that much, truthfully. The tech is there, yeah. But fundamentally, legal services is on the trailing edge of the technology adoption curve. It just is. And I think if you want to disrupt law, you have to recognize what the problem is. You have to be honest with the problem, right? And the problem is your market doesn't want to adopt technology, which is fine. At least be honest with it. And then you attack it in appropriate ways. But to assume that the law is going to be forward and we're going to be right there with autonomous vehicles, it's just not happening, right? It's just not happening. So I don't think, so law is going to change that much. One reason. That doesn't mean that if you get into the nitty-gritty, the law isn't changing. What surprised me is, and again, Chris and the panel, is like how technical the law has become. In sense, the amount of technicality in each sector, each subspecialty, it seems to increase exponentially, right? Like, you can't even have generalists anymore, right? You can't even have a generalist security lawyer anymore. You can't even be a generalist debt lawyer anymore. You have to be a high yield guy. You can't even be a specialist high yield guy. You gotta be a high yield guy that does Asia Pac. You literally, the level of specialization in the technical specifications required to be a good lawyer, that creates an opportunity. Because the more technical you make it, you open up room for technology to help you out. But what's cool as a vendor is, it creates a virtuous cycle for me, maybe a vicious cycle for the world, where the more technical the world is, the more you need technology, the more technical it makes the world. I'll give you an example. So my first product, IntelliGiant, my first company, it's used by half the public companies in America, all the major law firms and accounting firms to handle SEC filings. Right? My insight was, wow, if I could just see 10 risk factors from the similar subject matter, I can really help you draft better, right? Everyone else loved that insight. And what happened was, now, if your risk factors, if your disclosure varies from your peer firms, it impacts your stock price. So what's happened now is the average SEC filing has gone up by 50%. I actually don't know if I made the world a better place. I just basically added paperwork by 50%. Is what I did. I don't care, I'm rich, and they all got my product. But what happened is the world became more technical. The technology helped make it solve some problems, but because of that, it made the world more technical. Fundamentally, if you look at what a law firm partner does today, what's his or her job? Bring in the business, right? I don't know if that senior lawyer's job has changed that much from 10, 20, 30 years ago. Fine, they do it via telephone versus email versus fax, what have you, but their job has probably stayed the same. The associates, the people that are creating the sausage, maybe that's changed, but the senior lawyer, I think, probably does the same stuff, frankly. So in that sense, from a macro standpoint, I'm not sure how much tech has actually changed legal services. So that doesn't mean, and just a final thing, that doesn't mean that AI is not real, right? Again, I believe it. I started a second company, I believe it so much. One thing that I think people in the legal services sector don't appreciate is people think that the probability of automation is negatively correlated with lack of education. So therefore, those truck drivers and waiters, they're screwed, right? I got my grad degree, I'm off to the races, right? I'm fine, right? And it's just not true. Basically, if it's pattern-based, the machine will do it better. So any task, again, think about it. If it's pattern-based, process-driven, you can say X, deductive reasoning, X, Y, Z, you can do that task. So it's not going to solve that problem of how does a partner convince another client to actually do work, but that technical low-level task of doing that closing or doing that research task or creating that document or marking up that document, that can all be done with the machine. So the AI will help with that. But, the era of robo-lawyer, that's 50 years away. It's not going to happen anytime soon. So it's my 2 cents.
Well, that means we still have room for more dystopian movies in the meantime. So let me bounce some questions and start to draw this out. So Milo, starting with you, you talked about, in general terms, the GDPR is a game-changing event. It's going to have a significant impact. For those who don't do privacy or teach privacy for a living, can you help understand what it would mean for people? And I'll tell you, I actually do study the GDPR. I got a question from the Daily Pennsylvanian, and they asked me a very interesting question. They asked me, what does this mean for a Penn student? And it took me a while, but I did think of some things. I mean, realistically, it's going to obviously affect the companies, but there's going to be that are doing international business in Europe, but it's going to have some impacts on us. What is it going to do to us, and what is it about the law that's going to make it do that?
There's so many aspects of the GDPR, but I think one of the key ones is right at the very beginning in terms of collection of personal information. They define personal information so broadly. It's not just what's identifies an individual, but what could identify an individual. So think about that. What could identify an individual? And it requires consent before that data can be collected. So we're not talking about, okay, I've collected this, now I'm handcuffed in my way, I can use it or share it. It actually says you can't collect it. Now, when you have IP addresses, for example, defined as personal information, it almost breaks the internet. If you think about it, what they want to do, if taken to its logical extreme, is prevent any data collection without first asking your permission and having you say yes. And if you say no, it can't be collected. It's just not going to work. So it's not clear to me at the end of the day, how this all plays out. I also don't lose sight, a bit like a jurisdiction question. Used to be, federal, state, it's international, but there's a lot of that. The Europeans have said for nearly 20 years now that if a website drops a cookie on a browser of a European visitor, they have subjected themselves, the website, have subjected themselves to the jurisdiction of the European Union. And therefore, and to the rules, and therefore by not doing certain things, they've been in violation of the law. Well, that's been the case for nearly 20 years now. So again, we have to sort out what's significant, what isn't. They're claiming to have jurisdiction over US companies, even though the US companies don't have assets in in Europe, provided that they're doing enough in terms of collecting, again, personal data without permission, those kinds of, or at least without offering the opportunity. Come and get me, so to speak, in some respects. So the practical aspects, I think we're going to yet to be seen. I understand there's probably going to be a lot of forbearance in terms of enforcement over the next few years, just because they can't figure it out. They're way over their heads in understanding the implications of all of this. This is really a bit of an academic exercise, ivory tower passage of legislation versus real practicality. But what does, so I think that there'll be more and more pop-ups in some respects. Will be one thing you've already begun to see maybe. You'll start seeing as a way to address this. Again, what happens if you say no? Then, and supposedly, by the way, the other aspects about consent is that it's supposed to be voluntary. So, right, so I'm supposed to be able to say no with no consequences. What world do we live in where you can, I can demand that you give me all your services for free, despite my, my refusal to allow you to do anything, with information that I submit or subject here in this engagement. So I don't want to suggest there aren't any consequences, there's no implications, but I think, again, this is a process and it'll take several years to kind of sort that out. And I think that the Europeans probably in the long run will soften their approach and their interpretation to accommodate some realities that they are not fully appreciating right now.
So, I mean, just for the benefit of people who don't study this, one change, the GDPR no longer allows what we call blanket consents. You have to consent to every form of processing they want to do. So, they do tons. So you have to go click, click, click. You have to do individualized consent. And if there's an imbalance of bargaining power, no consent is valid. And in a certain reading, it's never balanced. Automatic processing of data, which is AI in the future, severe limits. So the question that strikes me is, when I talk to people in regulated spaces, the thing they fear is something that changes their business model. Limited time, limited collection. I still remember when they find Qualcomm $1 billion in China, I asked them, who's the big winner? They said Qualcomm. Why? They got half their revenue from China and they're still in business there. Now, the fact that they could write a check of any size and do that without changing their basic approach, fine. Are they going to have to change their business model for the GDPR, the major tech companies? And if so, is that the big threat?
I don't know. Let me play out another scenario. A scenario that says, I just don't know which will be the first company to try it. But let's take a social media company and there's several that have significant participation by Europeans, and they start putting all kinds of impediments, or they start charging for the services. And suddenly now, the constituents of the European policymakers start discovering a lot of discontent among the constituents, and the policymakers find that's going to create certain pressures, again, to either rewrite things or more likely reinterpret things in a way to accommodate the reality, certain business realities. I think there will be changes, but I don't think they're going to be draconian changes in the business model. I think that's going to, if that happens, it's going to take a while to happen. But one draconian, if you take one approach, would be a paid model. That's pretty draconian today. The other one would be, shutting down. That's another draconian. So I don't think that's going to happen anytime soon. But if a big U.S. social media company gets hit with billions of dollars in fines, or hundreds and hundreds of millions of dollars in fines, that's going to get everybody's attention. The question is, what is that for? What's the behavior, the fundamental behavior? What's the lesson? And regulators constantly, U.S., state, international, are trying to give messages to the marketplace. And so the question will be, what is it that that wasn't done correctly? But some business models, again, I go back to the very data collection. It's one thing to say you can collect that because that's the nature of the internet, but you can't do anything with it unless you do follow the following 5 steps. That's pretty restrictive to begin with, but supposedly, under the regimes, you can't even collect it in the first place. That's what's so, perverse, challenging, and just unreal.
So, Sagi, I know you're talking about the big future, but I want to go back to the industry you know the best, which is pharma. Mm-hmm. Pharma has undergone a dramatic change in the last 10 years. They're laying off research staff. The pipeline is dry. The big drugs that made it. What do you see as the future of this part of the industry? Because it's. Is there some change in business? what the niche drugs, big molecule drugs, what's going to happen to this industry?
Three comments. The first thing, I think it's important to distinguish between big pharma and everything else. So big pharma being the very large companies that are doing 25, 30, 40, $50 billion in annual revenue. They're the ones that have done a restructuring of R&D. And the restructuring essentially was to try to move some of the things that they used to do in-house and do it through third parties, so contract it out. And that is healthy, very, very healthy, because what is happening is that a symbiotic relationship has developed, and it's it's one that focuses on a higher level of efficiency. So the big pharma companies now are focused on what they do absolutely the best. That is, they can do international registration for a particular drug. So if you need to get a drug done in 50 countries and get it approved, they can do that kind of stuff. Smaller companies just don't have the resources to do that. If you need to market a drug on an international level, they can do that kind of stuff. Smaller companies just do not have the resources to do that. And they have massive checkbooks. They're generating a significant amount of capital every year. So having the industry spends roughly $80 billion in 12 months in R&D. So it's a huge checkbook. And that checkbook can be used to buy and to fund smaller companies. So the business model hasn't changed. It's just morphed to a higher level of efficiency. The smaller companies, there are many more of them, and many more of them being created, and most of them are being created by people who left Big Pharma. Mm. So again, I don't see that as being a radical change within the industry. What I do think, second point, what I do think is a radical change in the industry is that what I like to call the C word is being used more, and this is a positive C word, the word cure. The industry was built on, in effect, palliative care in terms of trying to manage the symptoms of diseases. And you could be on a drug for the rest of your life and for X number of months and the like. Now, you've got things like Havoni that pop up, and all of a sudden, people are talking about curing Hep C for a subset of patients and doing it in 90 days. Unheard of. So what is happening is that all of a sudden you're moving from a business model that says, you have a condition, I will continue to get money from you by treating that condition, to one saying, I've got a cure. So if you end up having a cure, well, that's one less patient. That's one less customer, okay? And that, I think, is a radical change. Mm. Now, not all conditions will be susceptible to that. But those that are, there's going to be a major push now to find cures. Not that there wasn't one before, but the science wasn't there for you to get there. Now the science seems to be available for certain types of conditions. And I think that's going to be huge. And Penn is actually on the forefront of that with regards to cancer and gene therapy and the like. That is going to be a radical change in the industry. I would say the third thing that is happening within the industry is the whole question of how are we going to be delivering drugs. We've done the pills ad nauseum, and we've done the injections ad nauseum, and we've done in France, we've done the suppositories and the like. But there's increasing technology that gives us a wider range of how we're going to deliver drugs. And I think that will also be a radical change. So the industry is changing, I think for the good. But I think those three elements was what will be driving that.
That's interesting. So Gary, one of the things everyone's all up in arms about is what are the limits to AI? One of the problems that actually we're blessed to hear being at Penn is to being a leading edge. And for those of you who don't know how AI is usually done, there's a lot of ways to do it on the technical side, but you have to, one typical thing is you have a data set, you divide it in half, you train the AI on half the data set, And then you use the other half to evaluate how it does. And you get a measure of how effective it is. And the criticism has been garbage in, garbage out. First, if it's not coded in the data, by definition, it won't emerge as a factor on the back end. And second is, if there's a bias in the data, or there's so the most famous person here probably is Richard Burke. He does looking at criminal sentencing data. If there's a bias built into the data based on race or gender or socioeconomic status, well, good AI will replicate it. And it makes me wonder, how does that concern play out when you're trying to put these products in the world, and is this something that you worry about? And
absolutely. Luckily for me, given I sell to the top law firms, these ethical issues don't really come into play. It's all the same people. So it's one corporation versus the other, so less of an issue. So we don't really struggle with these issues as much. But you're perfectly right. I mean, if you look underneath the hood, it's pattern matching and just trying to get those patterns as precise as possible. So in terms of the limits, there's a couple ways to think about this, right? So in my view, it's just a tool, right? So it's just a better mousetrap, and that's all it is, right? I think we're actually in a golden age. We're in an age of creatives, where if you're creative, define anywhere you want and apply in any sector you want, again, write your ticket in life. I mean, we're in a wonderful age if you're creative and you can monetize it. If your task is rote, process-based, then you're in trouble. And so for those tasks, look, the machine is pretty good. And again, people do mention the criminal justice aspect. So, what if you get a racist machine, right? And what do you do there and whatnot? 100% a problem, right? And I don't think anyone thinks that you should have the computer decide these decisions. But I would make two comments. That doesn't mean the computer can't be helpful in helping you guide that decision, right? And secondly, even from a theoretical standpoint, your measurement, your metric isn't the ideal. It isn't batting 1,000. Your metric is the person, right? So, if the person is, 70% accurate and the machine is 80% accurate, well, yeah, that's awful, but that's still a net improvement, though. Especially if you combine the two, then ideally you get even better. So I think people need to remember what the baseline comparison is. Yeah.
Well, I think that's huge. It always strikes me every time an autonomous vehicle gets in an accident.
Right.
There's a default, well, that's terrible.
Right.
And the question you're asking is, as compared to what, in a world where human error is the biggest source of accidents to begin with? But here's the question. It's quite likely that, first, if you're using AI, errors will be there. I mean, just statistically, there's no perfect solution. And second, it's quite possible, the hard scenario in my head is, if the errors are of a different order and create either a different kind of harm or a different magnitude of harm, how do we deal with this? So in your world, a malpractice action. Mm-hmm. Obviously, humans reviewing documents have their disadvantages, but my guess is it's quite possible that your software reviewing documents might miss a particular kind of error with a higher frequency than humans will.
Yep.
How do we play this out?
Sure. And it's something that, whenever I hire lawyers, the first question they ask, like, look at the liability exposure. My God, what if we get this wrong, right? And, well, I'm an entrepreneur, so I'm kind of sanguine about it. But honestly, I think the folks at Westlaw and Lexis have already solved that problem. Look, they miss things all the time. If you think Shepard's is 100% accurate, my gosh, right? So that problem has already been tackled, and the way to tackle it is you, lawyer, it's your responsibility, right? I can indemnify you, but I'm a startup. I'm not going to indemnify you. You know that. So it's fundamentally your responsibility. So there's definitely a risk. So again, just use an autonomous vehicle analogy. If you're a trucking firm, you can have the machine go down that highway and it'll drive for 24 hours. It'll do what it'll do. But yeah, once in a while it'll mess up, versus the sleep-deprived truck driver that's going to drive for 20 hours and is also at risk, right? So what I found is, so lawyers struggle with this, by the way. Lawyers struggle with this. Luckily for me, the clients don't. The folks at in-house, the corporations, they're actually relatively sophisticated. They kind of get that. And again, most people have insurance. None of these mistakes are typically life or death anyway. And people are good about it. People are good about it. That's what I found anyway.
You have to say something, Wasage, I can see.
So, two comments. The first one, as much as I enjoy theoretical discussions, I love practical data even more. So, a couple of years ago, Deloitte deployed a AI, okay, the Kira system. Over 6,000 of their employees got access to the system. Now, most people don't know, but Deloitte has the largest law firm, one of the largest law firms in the world, outside of the US. And so that was the largest deployment of AI into the legal field at one fell swoop. Likewise, the same software platform, Fenwick, Freshfields, Latham and Watkins, Davis Polk, all of them got on the platform. This has already led to a significant reduction in billable hours for young associates. This is not a theoretical debate about whether this is going to have an impact on the practice of the law. It already has an impact on the practice of the law. And that means it has a direct impact on what law schools do as to how do we prepare our students to go into the workforce. It has a direct impact as to what a first year, second year, third year associate does and how they get trained. And it has a direct impact on how the law firm bills its clients and what his clients are willing to pay for. Of course, the senior partners are fine because they've got gray hair and they have experience. And what the client is paying for is their judgment call. The AI won't give you that. But the grunt work and the grunt work through which we train young associates, that is under direct attack as we speak. That's not a theoretical debate. These are just the facts. And the ABA has run several programs talking about this issue. So from my perspective, that is real, and we need to think about that. Flip to the other side. Right now, there's a program in Stanford led by, maybe you know him, Professor Greeley. And he's the director for the Center for Law and Biosciences. And they are doing brain scans, which they are trying to bring into court as a basis of evaluating motive and having a direct impact in the criminal justice system. This is not theory. This is fact. I mean, they are talking about doing brain scans to determine whether or not you have the right mens rea that forms the basis of a crime. This is an impact of technology on the direct practice of law that is, and it's going to affect every single one of us. So all of a sudden, the whole question of what juries are doing, the whole question of so-called eyewitnesses, where we know already there's a huge amount of variability, it's going to get a little bit more rigorous, and it's going to be technology that is leading the way in that regard. So I do think that the elements that are going to have a profound impact, both on the way we train lawyers, the way we practice law, and what happens to all of us who are subject to the law. And I think technology is going to be driving that.
Well, it's going to be driving it, but I really want to pin you down. Using brain scans and the brain mapping and the activation to be able to discern motive, if I understand, you're implying is a good thing.
I'm not sure. You see, this is the issue. I think we are in a period of anomy, a complete fluid period right now. I'm not sure. In theory, and this is part of what the Catrone Center is doing here at Penn, in theory, if we get more hard data, we can make more rational decisions. But my concern in part is the garbage in, garbage out issue, and the fact that I'll talk for myself, we tend to have a very quick period of atrophy. I can't remember anyone's phone numbers anymore. I used to remember everyone's phone numbers, right? And the reason is I have a bloody phone. So atrophy sets in, we become dependent on technology, and we don't do enough of standing back and saying, well, what the heck are we doing? What, does this really work? What is this doing? What I am pointing out is that this is already happening. And because we have this love affair with technology, we tend not to, in my view, question it enough.
Hasn't that changed, though? I mean, I think we've had a 20-fair love affair with the internet, and it seems to be different right now. I mean, is my perception off?
A speck in time. So how many people have gone off Facebook? How many people have stopped using the internet? How many people have given up their phones?
I think people are seriously thinking about leaving Facebook for the first time.
Yeah, to go to another platform.
Correct.
Yeah, but this is ridiculous. Yeah. We have become absolute addicts to this. And if we think that this is no longer part of our paradigm, we're kidding ourselves. It is part of our paradigm.
One thing I was going to mention, in terms of some of your questions earlier, I think the questions are the right questions to ask, but for the students who may be in the audience who may be thinking the end is near.
The end is not near. Don't get me wrong.
I just wanted to say, I remember when Lexis and West were the computerized legal research came around, and both as a student as well as a young associate, and the questions were like, well, what's going to be left for the young associates to do? And the clients asking, why am I paying, $150 for something that took 5 minutes? And I said, well, because it would cost $600 if a human does it. And so the issues are there. The danger of seeing the past, or deja vu, is that you don't recognize the uniqueness of the new situation. So I'm not suggesting there isn't, but I embrace your questions. These are the right questions to ask. How does it impact education? How are we preparing students? But I think that somehow the law and the business of law finds a way of filling the gap.
The beautiful thing about business is that it's a transaction, and you need someone on the other side to pay. Forget the lawyers. What are the clients saying? What are the clients saying? If the client has access to a piece of software where he can get a contract knocked out, why would he pay you? Because he likes your face? Really?
I don't go to a computer for the will in the States or for So
my point here is this. When I started practicing law, we had a whole floor in my law firm of secretaries. We would work with the young associates, we'll give them a document, and then we'll go home. And they will spend all night typing it up. And those were the days of Hayes modems. And I got the first Hayes 1200 baud XNR modem. And in the middle of the night, they will send me my document. And I thought I was the coolest thing since sliced bread. You show me one law firm now that has anyone doing that. It's gone. So the reality is that, yes, the business morphs. But the bullet that kills you is the one that you don't see. And my point is that let's be very clear what the reality is on the ground. AI is here, is doing grunt work. Young associates need to have different skills. Young associates have to be therefore trained in a different way.
So I have to admit, when I hear we saying, oh, things aren't going to change, or we'll work, let's muddle through, I keep thinking of AOL. And once upon a time, they curated the internet, they had everybody, and when AOL keywords were a big deal. And we made a whole lot of policy, and we almost blocked a $200 billion merger, the largest still this day, I think, in the world, over what turns out to be harms that were largely speculative. On the other hand, there are changes that matter. Have we learned anything about separating what's important from what's not important? I mean, how do we advise clients? But I'm looking at Tom. I mean, he's got not just clients, he's the principal putting money on the table. And the thing that I get frustrated with is the type of, it's complicated. Well, thank you. Help me. And I'm finding myself, we're talking kind of hedging around it, but this seems to be the problem right now is, trying to find heuristics or analytics that get traction on these problems.
Let me suggest a paradigm that I think privacy front may offer not a new way, but an approach, a path forward. It requires, people to want it, so to speak. You got to have enough trouble and problems with a particular paradigm. But we've been living for decades now in an approach which is essentially known as notice and consent or notice and choice. If I had like a diagram, I would take that and from that one circle, I would move it down to one side and create two new bubbles. And I could see a world where we try to develop a regime. It doesn't matter whether it's the law, probably it would become the law somewhere, or whether it's industry standards and codes, but essentially an approach that says we're going to identify the kinds of data collection practices, the data uses that we as a society believe are worthwhile, and we're going to allow to happen, no notice or consent. There's no reason to ask for permission or anything like that. And you can ask for permission in what's called opt-out, opt-in, which means the default is I can go ahead unless you object, but the point is it's a form of permission. But no permission required. These are important aspects for society, important aspects for our, for industry in terms of the economy. We will then identify a universe that should require some kind of permission in order to proceed. So these are not pre-approved, so to speak. These are ones that will require some transparency to consumers. And then over here, there'll be some prohibited practices. Practices, doesn't matter. You can't consent. You can't agree to that. It's just prohibited. It's harmful. Back to your harmful concept. So you can have, again, move from the current notice and consent with lots of criticism. How can I figure out that that's the case? Where in my Facebook agreement? Where in Twitter? But rather, move it aside, figure out what is it that should be proceed. But you need, again, enough trouble, maybe with the GDPR implementation, maybe with efforts to come up with legislation in the context of these hearings that are taking place this week. But a world where we move to something which is actually an old model, kind of the Fair Credit Reporting Act model, which says these are permissible. This is okay. And you can do it in different areas. You can do it across the board. You can do different areas. To the extent that a lot of what's going on here is what's called digital advertising. There was an article in the New York Times a few months ago, in the beginning of the year, kind of putting the root of all evil on digital advertising. And that you start with, okay, advertising is here to stay. Would you prefer to get random advertising or targeted advertising? Would you prefer, as law school students, to get some ads about colleges that you might want to apply, or law schools? You're already in law school. That doesn't matter. That's not relevant to you. So you want things that are relevant to you. That's good. It's also good for business to be able to target ads, right? It's more, and so you need data for that. I mean, so you could see a syllogism where you go through and identify, again, some practices that are good. You can also recognize practices that are bad, and again, put them either in a prohibited category, or if they're gray, put them in a one where it's a smaller universe of notice and choice. That, I think, is kind of a way I could see in the next several years things developing. Again, it's not going to happen tomorrow. We're still tied to certain paradigms, but I can see that that might be a way through some of this maze.
Chris, to your question about have we learned anything? I think one of the things we need to, and I think academic institutions like Penn are really great, and the center, I think, would be great to really attack this. We are using 18th century, 19th century concepts to try to deal with the 21st century technology. You know, we teach students about copyright, and then we teach them about patents, and we teach them about unfair competition, confidential information and the like. So we have these boxes, and we're trying to fit things into those boxes. Maybe it's time for us to fundamentally rethink the whole space of IP. Maybe we need other boxes. Even with privacy, you know, now people are saying, well, is privacy, what is that? Is that a particular form of IP? Is it a completely different product itself? And I think that we may be at a point where fundamental questions about what we've been brought up to believe, or what we believe are the right ways of looking at intellectual property that need to be revisited.
My view on AOL and just tech adoption, the lesson from AOL was that you don't bet the farm on new tech, right? Unless you have to, and they didn't have to, right? So if you're a trucking firm and you love Elon Musk and you see those automated driving trucks, I mean, you should probably still train young drivers, right? I mean, you should hedge your bets. But making big bets, I mean, who's to say? I mean, you know, people say AI is new. You know, not really. 10 years ago, we used to call it big data, right? Same concept, right? And people say blockchain is the next new thing. Is it blockchain or AI? I don't know. Neither do you, right? So my lesson from that is don't make big bets. Hedge your bets, but don't bet the farm on tech.
That's interesting. Well, I could keep asking you guys questions, but we have a few minutes left. I'd like to open up the floor if there's any others, questions people like to ask. Go ahead, David. While you're going to the mic, I'm going to throw out another question. In a world where go ahead. So I keep thinking of GMOs and I keep thinking of AI. It's easy to think of horror scenarios. And that's what I'm sure you're constantly marketing against them. And it's particularly hard in a world against data, but is this an empirical question or do people not care?
You know, look, the incumbents obviously have marketing power, and the incumbents obviously want to maintain their entrenched position. But I'm not too worried. I think, you know, the innovators also have their champions and whatnot. So, but you're 100% right. Half of it's just hearts and minds, right? I mean, there are people that just do not believe in GMOs. You just can't, it's religious almost, right? Data doesn't make a difference, right? There are people that think they don't like the machines, even though you can give them empirical data. You know, like, my God, for me, like, when I look at, for example, autonomous driving, I mentioned that a couple times, you know, there's what, 40,000 deaths in the US every year. There's what, 4 to 5 million accidents. Wow. I mean, that's just a lot of havoc and pain in the world, right? That's the Vietnam War every year, right? Gosh. And if tech can solve that problem, Jesus, we should be like all over it. But again, I'm biased. So I think it's an arms race that's everyone's evenly matched, but tech will probably win.
David.
So this has been fascinating. You've raised a lot of tough issues that are going to come down the pike or already we're facing right now. I'm curious whether you think that lawyers have special training or ability to deal with them, or special weaknesses in relation to dealing with them in the public sphere. Second, should law schools be thinking about training their students in a particular way to engage publicly with these issues? And third, how have you engaged publicly over the course of your careers, and what has been fruitful and enjoyable for you in that regard?
Well, let me take the last one first. I've always felt the need to be part of my community in various ways. Now, I do it in legal-related ways, but in my case, my first month in a new city in Washington, D.C., when I started practicing, I went to the Hispanic Bar Association, and there was a whole range of issues having to do with the lack of interpreters in the courts, and so I worked on that. They were using janitors to pull in for criminal cases. It was just a horrible situation. And in a year and a half, we got budget, we got legislation passed, and that led me to work with the local ACLU, and I also was working with the Visitor Services Center, which has to do with the DC jails. So I've always had an involvement in it, and it really helps round out. It keeps on going. DC Bar Foundation, in terms of the largest funder of civil legal services in DC. I find that to be, my work is very satisfying, but I find that I want to give more, and so I've always found time, and the one piece of advice I would give on that is find time early, because you'll find 1,000 excuses not to do it. I just, that's something I started, if not in high school, in college. I just started doing it, and then you may cut back a little bit. I was teaching one of the first information privacy courses as an adjunct in the early 90s. Married, started having kids. I cut back that, but I started continuing to do some of the other aspects. As to the role of lawyers, I was very, most recently, in the pharma area, I found remarks by Ken Frazier from Merck, where he was giving the story of how he was outside counsel, and then became general counsel, then he became CEO, and as a CEO asked him to do more things, he said, I'm just a lawyer. He says, no, you're more than a lawyer. You've got to be more than a lawyer. And you bring a lot to it. You bring the right way to approach issues, asking the right questions. So I think that first and foremost, you got to do your job, whatever that job is, and show your value and show your smarts, and then start, taking ownership of the business issue. If you're an associate at a firm, which is what I'm most familiar with, again, do your job, but then start thinking more broadly. Think like, not just do your job, but what else can I do to help here? What's the client's problems? Maybe they're not asking the right questions. Let me answer their questions, and let me start thinking about the questions they're not asking. So I think that's a lot of, lawyers can bring a lot to the table as you get better equipped, more about technology and data become, for example, some of the leading indicators. Then you'll be better equipped to ask the questions and understand the answers. But I think there's a role for lawyers to be more than just, in a very narrowly confined way, lawyers. But I wouldn't want to encourage you to not to do your job. You got to do that first and then go beyond that.
Three quick comments. The first one, we live in a complicated world, and that world is just going to get even more complicated. That's reality. In terms of what is happening with lawyers, I think because of the first point, because we live in a complicated world, the multidisciplinary, cross-disciplinary approach to the training of lawyers, which Penn has been doing for the last 2 decades or so, I think is absolutely crucial. Think about it. We are now in a situation where most students who graduate from Penn Law have a joint degree and or a joint certificate. And that has enabled, and we've seen the practical impact of that. The law school has been able to be one of the top law schools in placement of students. Mainly because you get more bang for your buck. You're not just getting a scrivener, you're getting someone that has a slightly broader perspective. So I think that legal training in terms of a multidisciplinary, cross-disciplinary approach is absolutely crucial to prepare lawyers for the 21st century. My third and final comment, I've gone through 5 professions. I did that because I'm internally, just eternally curious. I've ended up in the last couple of decades in pharmaceuticals without my brother is the doctor, not me. And yet I've run groups in R&D in big pharma companies. But I've gone 5 professions. You're going to do that just because you have to, because the world is changing so fast that some of the professions that exist now will not exist in the next decade. If you look at what has happened, go and look at the companies that are on the indices. Many of them did not exist 20 years ago, and yet they're now multi-billion-dollar companies with close to $1 trillion of cash in terms of one of them. So my point here is that you have to really commit yourself to a lifetime learning, not just the words, but the mental attitude that is required to do that. And the ability to learn new skills and to go into new professions, I think, is absolutely crucial.
Gary, you get the last word.
Yeah, very quickly, I think the future is quite bright for law students. I think, looking at my generation, the folks that graduated pre-financial crisis, I think a lot of us went to law school because why not? We didn't, it was more of a negative reason, like, hey, nothing else, might as well go, and it's a safe, secure job. And I think the financial crisis just really upended all of that. And I think from what I've seen, and maybe I'm wrong, but from what I've seen, people come into law now with eyes wide open. They realize there's an opportunity cost. They realize there's a massive capital investment. And they realize how the legal world works now. I think there's so much more information that we just didn't have, right? I mean, what the partnership rates are. You know what your odds are to getting into a big firm. So the people that make that proactive decision have a greater, I think, confidence and conviction of why they want to be lawyers and what they want to do. Which I don't think existed, frankly, in my cohort 10 years ago. And I think that's going to set us up very well, because especially in a world where we live now, where, frankly, you don't have fidelity to the rules. And someone that does care about the rules and a fidelity to, I think, is more critical than ever.
We've reached the end of the time. I'm sorry if there's other questions. Please join me in thanking the panel for a scintillating discussion about the future. I now invite